Hey everybody, this is Patent Paul, and I'm going to talk briefly about when you need to file a patent application. The main reason that timing is important is that any kind of public disclosure of your invention generally starts a clock ticking, and if you don't file within a certain time period of that first disclosure, then you might not be able to file. You might get away with it if you file a patent application and get something issued, because patent examiners don't generally check for this kind of thing. But if you later try to enforce your patent against somebody and they find out that you disclosed your invention more than a year before you filed, then your patent will be invalidated. So generally you just want to be careful about these dates and make sure you get things filed on time. It's also important to keep in mind that what counts as a public disclosure can be pretty broad. Sometimes inventors think, well, I have only disclosed it to a few people, and I told them not to share with anybody else. But technically, those still might be public disclosures. And you should keep in mind that any disclosure you make to any single person who doesn't owe you a duty of confidentiality, that might be a public disclosure. So, if you say that you told them to keep it secret, that might not hold up in court, and it might be considered a public disclosure still. But if you have a signed non-disclosure agreement from somebody, that's pretty good, especially if it's well drafted. So, one of the first questions you should ask to figure out the timing is whether or not you're going to focus only on the United States in terms of where you're going to sell your invention, or if you're also going to want to sell your invention in foreign countries. A lot of things go into that consideration, but generally, it's based on what the market is like for your invention in those foreign countries and how much money you have to tap into that market. If you're a solo entrepreneur, if you're trying to keep your costs low, if you're doing your inventing as a side gig, then you might not want to focus on foreign markets because they can get expensive really fast. So let's say, for example, you're only going to focus on selling your invention in the United States. Technically, you can market and sell and offer for sale your invention for up to a year before you file any patent application in the U.S. This is called a grace period. The grace period in the United States is 1 year. There is some risk involved in waiting to file, because if somebody else comes up with your invention independently, meaning they didn't derive it from you or from your invention, and they file before you, well, then you lose, and you can't patent your invention, and they might be able to patent it. But that risk may or may not be a big risk. This is a business decision. And you may decide that the bigger risk is just keeping your business alive to begin with. So let's say that you take that risk and nobody else files before you. Let's say at the end of that 1 year, you then file your U.S. patent application, which can be a U.S. provisional patent application. And if you file a provisional, that allows you to keep your costs low and give you an entire additional year of marketing. Then at the end of that second year, you have to file your U.S. non-provisional patent application. If you go this route, it kind of allows you to get 2 years of marketing for a pretty low price, which is just one provisional patent application. On the other hand, if you do care about foreign markets, in other words, if you want to sell your invention somewhere outside of the United States, the best practice is to just file first in the United States before you make any public disclosures or sales or offers for sale at all. And the reason for that is because almost every foreign country does not have any grace period at all. Some countries do. Canada, Australia, and Japan have grace periods. Some countries have a grace period of 1 year. Some countries have a grace period of 6 months. But most foreign countries have no grace period. So the best practice is, if you're going to sell your invention in any foreign country, just file your U.S. patent application first before you make any disclosures at all. This disclosure could be something like posting a Kickstarter campaign or offering your invention for sale on a website. Those count as public disclosures. Sharing your invention with venture capitalists, who often will refuse to sign non-disclosure agreements, that generally can count as a public disclosure as well. So it's risky. You need to make sure you have something on file before you do those things if you're going to go foreign. But your first filing, again, could be a provisional patent application, and that allows you to market your invention for 1 year And then at the end of that year, you then have to file your U.S. non-provisional patent application. And at the same time, you either have to file directly in individual foreign countries, or you have to file a PCT patent application. And a PCT patent application kind of acts like an international provisional, and it extends the deadline to file in foreign countries for another 18 months. And then at the end of that 18 months, then you have to file in those foreign countries. So that's basically it. There are other things to keep in mind. You can go other routes. For example, you can skip the provisional in either case. One reason you might do that is so that the examination process starts more quickly. Because remember, a provisional patent application doesn't get examined. It just holds your place in line so that you can later file your non-provisional patent application. And sometimes clients want to find out relatively quickly whether their invention can be patented, and they just want a final decision on it. And if that's the case, you might want to skip the provisional patent application if you have the funds to go straight to the non-provisional. It's also important to keep in mind that technically a provisional is an added cost that you don't have to expend if you go straight to a non-provisional. A provisional allows you to keep your costs lower up front, but it can be more costs overall because you're paying for the provisional. But generally, I think it's a good idea for a lot of clients because while one big question is whether your invention can be patented, an equally important question is whether or not your invention is going to make money. Because if your invention isn't going to make money, there's really no reason to patent it. So the provisional patent application is useful if you feel like you want to figure out quickly whether you can make money on your invention. It allows you to market and sell and just see how many sales you get. At the end of the day, you can then decide based on the sales you make or the sales you don't make, whether or not it makes sense to spend money on a non-provisional patent application. And because of that, when I'm talking to clients about timing and when to file and what to file, I often recommend that if they're trying to keep their costs low and test the market, it's a good idea to start with a U.S. provisional. Another thing I'll point out that I should have mentioned earlier is that if you're only focusing on the U.S. market, you should keep in mind that a U.S. patent protects against infringing imports. So if you're worried about somebody infringing your patent by manufacturing it in another country and then importing it into the United States, that doesn't necessarily mean you need to get a patent in that foreign country. Your U.S. patent should protect against infringing imports. It might be costly to stop those infringing imports, and it might be easier to stop them if you have a patent in the country where they're manufacturing it. But it might also be much more expensive to get 2 patents instead of 1. So, if you want to keep your costs low and your only market is the United States, again, you might just need a U.S. patent. As a final note, I'll just remind you that some countries do have grace periods. And in some countries, what counts as a public disclosure in the United States is a little bit different than what counts as a public disclosure in that country. So, if you think you missed a deadline, but you still want to file in some foreign country, your U.S. patent attorney can still check with foreign counsel and see whether under your circumstances you can still file there or not. Sometimes you can, sometimes you can't. So if you want to be on the safe side, if you're going to go foreign, just remember, file first. Anyways, that's it for today. Comment below if you have any comments, and feel free to visit my website at patentpaul.com. Thanks.